our CACR number 200043, State of Arizona versus James Hunter. Thank you, counsel, for participating with us virtually. And I understand that we have Lisa Martin from the County Attorney's Office on behalf of the state, and Sharmila Roy, now from Naperville, Illinois, representing Mr. Hunter. Counsel, in a moment, I'm going to start the argument, but I would let you know that we have conferenced this case. We've read the briefs. We are familiar with the record. We would just ask that you keep that in mind when you present your arguments. Please, when you proceed with your argument, identify yourself for the record. There is a timer on the Teams meeting screen that will keep track of your time, and I'm assuming that you can see it since I can. Ms. Martin, as the appellant, you are responsible for letting us know if you would like to reserve any time for rebuttal. And with that, Ms. Martin, you may begin.
Thank you, Your Honor. I would like to reserve time for a rebuttal. Successful at managing to do that, but I will say that I'm going to reserve time for rebuttal and hope that I actually can. I would like to start off by just quickly covering the issue of, did Judge Hanna, the trial court judge, actually grant a new trial in this case, even though he said he did? And he said that he was granting a new trial on the element of the offense that made it a felony, which was the intent to promote further or assist the interests of a criminal street gang. However, the court never actually set the case for a new trial on the greater offense. And it said that it was not granting a new trial on the misdemeanor offenses. So there really was no new trial granted, because if there was a judgment entered on the misdemeanor offenses, there couldn't be a new trial on the greater offenses, because that would be double jeopardy, because actually the lesser included and the greater would be the same offense. So actually what the judge did, while purportedly using the new trial standards, was to bump the 3 felony verdicts down to misdemeanors. And that is not what Rule 24.1C, I'm sorry.
Ms. Martin, what Judge Hanna did is simply determine that there was insufficient evidence on the greater offense.
Well, if he was determining there was insufficient evidence, then he should have used Rule 20. Because Rule 20 would have tested the sufficiency of the evidence, but the court denied Rule 20 before the verdict, or denied a Rule 20 at the close of the state's evidence, and the defense did not renew that motion for acquittal either at the close of the state's evidence or after the verdict. And the court did not on its own grant a Rule 20. The court specifically said it was using 24.1. See, I'm sorry? Did someone say?
I don't believe so.
Okay, I was hearing an echo of probably some of these watchers. Anyway, I'm sorry. So the court said that it was granting a new trial motion, and it wanted to use the standards of granting a new trial motion, which gives the court broad discretion to actually to reweigh the evidence and to ignore inferences in the evidence and to assess the credibility of the witnesses. And that's what the trial judge said that he was doing, and that he found that there was it was basically going to be an verdict if it was the felony counts of threatening and intimidating.
Is it the state's position that the trial judge lacked the authority to direct a verdict in a Rule 24 motion?
In a Rule 24 motion?
Correct.
Yes, because a Rule 24.1 motion, by its literal terms, says that the court is trial. And the Arizona Supreme Court in 2017 in State versus Fisher clarified what the role of the trial court is in granting a new trial. Although it has broad discretion, the court can't simply substitute its own opinion for the jury. It is the 13th juror, so almost in effect, it can hang the jury, but that means there's actually got to be a new trial. That's how a new trial motion is different from a judgment of acquittal. A judgment of acquittal completely disposes of the case or disposes of, say, an aggravating factor, but the motion for a new trial does not supplant the jury. It will be tried, but before a different jury. But in this case, the judge just bumped them down to misdemeanors and set it for sentencing. And what is stayed by this appeal is actually the sentencing and the accompanying disposition, because the defendant was also on probation. So it's not, even though he said that he was granting a new trial, he did not grant a new trial. So at an absolute minimum, the felony verdicts would need to be reinstated for a new trial. But the state goes beyond that and says that this is actually a case where if the judge had done what he thought he was doing and actually was granting a new trial on the greater, on the felony offenses, then there are so many legal errors that the judge actually did abuse his discretion, because he, even taking what the standards of Fisher are, the judge did not comply with that. The judge absolutely viewed the evidence such that he ignored a great deal of the evidence, and actually, in a sense, no disrespect intended, but actually made up evidence. In the part where he talks about the expert testimony, he says, well, yes, I did preclude Detective Silvestri from discussing what the defendant's state of mind was if the defendant actually was intending to promote the gang. I let him just talk generally about what are the goals of gangs. They want respect, they want credibility. And so, yeah, I precluded Detective Silvestri from doing that. But if Detective Silvestri had been allowed to testify as to that, the jury could have presumed that he would have said that, yes, the defendant was intending to promote the gang. So then the jury would have trusted Detective Silvestri because he was a police officer and knew more about this than they did, and they would have adopted his findings. And that's just what Rule 704B of evidence was designed to prevent against. So the judge assumes that the jury ignored their instructions, agreed with evidence that doesn't exist, and made a finding in violation of the rules of evidence, which he had precluded. Now, that is multiple legal errors. And even though the standard is an abuse of discretion, interpretation of a court rule is de novo. And this is just not in line with what Fisher has said about what a new trial order is for.
Well, Fisher also said that the Court of Appeals should basically butt out the trial judge.
Not completely but out, Your Honor. This court is there to oversee the granting of a new trial, to ensure that the trial court's discretion has a legal rather than an arbitrary basis, and that substantial evidence exists to support the trial court's determination. So you're butting out in the sense that you're not determining whether the evidence supports the jury verdicts. Clearly it does, but you're supposed to ask whether the probative force of the evidence supports the order granting the new trial, and it does not.
Even if we excluded what you just went through regarding the expert witness, isn't it 14 pages that Judge Hanna wrote regarding all of his disagreement and why there should be a different result in this case?
Yeah, I'm sorry.
We start striking some of them. There's still substantial evidence to support his determination, isn't there?
No, there isn't, Your Honor. I just gave one example so far, but there are more. For instance, the judge says that it really doesn't matter that the police officers all felt threatened, that they were in front of the penultimate gang house in the middle of the West Side Crips neighborhood with everybody and their brother coming out of the woodwork in a hostile environment, and the defendant screaming that he was going to start a war against the effing pigs, and invoke the West Side. And the judge said that doesn't have necessarily anything to do with the gang, because there's a perfectly reasonable explanation for why the defendant was saying those things. And the explanation that the judge comes up with is that it was Thanksgiving and the defendant's girlfriend's car was being towed away. And the court said, well, gee, anybody would be angry under those circumstances. And the court also adds, which is illegal, that he had been drinking, which made him extra aggressive. Now, when the defense was arguing the new trial motion, the defense brought up, oh yes, the defendant was drinking, and you should take that into account. And at the time, the judge said, let's see, the guys up the street are pretty clear about that I'm not supposed to do that. And no offense, Judge Bailey, but the guys up the street are you. And so the judge tells the defense in the new trial motion argument, I can't take alcohol, the voluntary intoxication, into account, but there it is in his order when he grants a new trial that the defendant was aggressive because he had been drinking alcohol. And if that doesn't go to state of mind, I don't know what does. So that was illegal. And even if the defendant was angry that the car was being towed away and it was Thanksgiving, that doesn't mean that his intent couldn't have also been to promote the gang. It's just clearly against the actual weight of the evidence that the judge would supplant a jury verdict by saying it all had to do with a car being towed away. The judge also says, discounts many things.
Hold on, Ms. Martin. I think that Judge Bailey.
Is there any kind of, is there a rule you have in mind, some sort of carve out to Fisher that would allow us to make any kind of different determination when we're talking about intent? Here it feels like it's a little bit different than Fisher in that nobody's disputing what the evidence was, what the facts were at the scene. The dispute and what Judge Hanna seems to be focusing on is what Mr. Hunter's intent was when he made those statements, which is different from Fisher in that was about what did the facts show, what did the accumulation of the circumstantial evidence show, as opposed to that murder case. But here we're focusing on intent. Is there any different way that we can look at it in light of what we've been told in Fisher?
Well, I think you don't need a carve out from Fisher. I think you just need to look at the holdings of Fisher, because Fisher clarifies the judge's the overview of Fisher is it clarifies the judge's role. The judge cannot set aside a jury verdict simply because he would have reached a different result or disagrees with the jury's resolution of conflicting facts. The judge's discretion is not unlimited. He's not a super juror who can veto the jury verdict simply because he personally disagrees with it. So this, when you look,
have a minute entry that seems to do both. That he can disagree with it on the basis of Fisher and also make comments that may telegraph that he disagreed with it on a personal level as well. Does that mean that we can't affirm his decision?
if it were just a few, I'm sorry.
No, go ahead.
Okay, if it were just, you know, a few comments about his personal feelings that were littered throughout other legally valid reasons, that would be different. But here, the judge, there's just an abuse of discretion in terms of even when he comes up with the evidence of intent, because he kind of like splits. Instead of doing a full consideration of the case, like Fisher says, he basically splits it into parts and then does like divide and conquer and tries to eliminate each part. So the first part, he says the statements are really about towing the car away. The second part, he says, oh, the evidence is really kind of debatable whether he was a gang member, which the state doesn't have to prove anyway. But the judge discounted any evidence even about the gang house and the videos, saying, oh, that's culture and you can't criminalize culture. And then the judge makes the state have a burden that's not anywhere in the law, saying that unless Mr. Hunter actually subjectively thought that he could succeed by his threats in keeping the police out of that neighborhood, then he couldn't have had a motive and therefore couldn't have had an intent to promote the gang. And that burden, whether it's just not in the law, it's not necessary for that to be proved. There's no case that says that that the defendant has to actually subjectively believe that he can keep the police out of his neighborhood. And the judge says, with my superior expertise and experience, I can see this better than the jury. And I know police culture, and I know that police are not going to stay out of a neighborhood enforcing the law just because a gang member threatens them. But even the facts of this case show that the police did do some things differently because of these threats. They did not arrest Mr. Hunter that night. They threw the car on the tow truck and took it around the corner to attach it properly because they were afraid with all these people coming at them and the defendant invoking the gang and screaming at them. And they didn't even finish the DUI investigation of the driver of the car, which they would usually do. So they actually did not do things they would usually do because they were afraid, because he was threatening them. And yeah, maybe he eventually did get arrested, but the police were in fear, and there was an effect. The defendant had an audience of people that were hostile to the police, and he took advantage of that.
Judge Hanna did affirm the threatening part. It was whether or not it was intended to benefit the gang. So, I mean, those arguments would they would be sufficient, I guess, if he hadn't made that determination, wouldn't it? I mean, there's no dispute that Judge Hanna believed there were actually threats being made.
Right, but I think when the judge says that the state has to prove and failed to prove that Mr. Hunter had an actual subjective belief that he would be successful in keeping the police out of his neighborhood, well, that goes to the gang part of the threats. That goes to the fact that he says, I'm going to have a war with you police. And the whole goal of the gang is to intimidate and to control and to build respect. So he's there and he's showing to all these people in his community in front of the gang house that his mother owns and that he used to live in, and that the car drove to, kept evading police so they could end up right in front of that house on Pima where they made gang videos. And he's standing there saying, they don't scare me because I'm going to have a war. The West Side City Crips are going to have a war. They don't even know what's coming. And the police pile up their stuff and leave. So that does promote the gang.
Ms. Martin, you have 2 minutes remaining.
Oh, okay. I'm going to reserve my 2 minutes unless there are any questions.
No, that's fine. Travis, you can pause her time. And we'll now hear from Ms. Roy.
Good morning, Your Honors. This is Sharmila Roy. On my screen, I'm only seeing the clock, not your faces. So I'm not quite sure how I would determine who's asking the questions. But may it please the court, this is Sharmila Roy and James Hunter. So I can hear you, so that's, I guess, all that matters. I just want to first comment that the Fisher standard is that the probative force of the evidence demonstrates that the trial court's action is wrong and unjust and therefore unreasonable and a manifest abuse of discretion as the standard that this court must use when reviewing the grant of a motion for new trial. So, and every conflict in the evidence must be resolved in support of the order. So what the jury did and whether it was justified in doing that is actually not an issue here, because even when a verdict is supported by sufficient evidence, there can still be a motion for a new trial.
Ms. Roy, do you agree with counsel, though, that there were errors in the judge's particular findings?
I'm not sure which I would consider as an error, but...
And okay, I'll rephrase the question. If we were to determine that there were errors in Judge Hanna's findings, how do we handle that if we're reviewing whether it was an abuse of discretion?
Well, I guess if you think about something being wrong and unjust and manifest abuse of discretion, that's a little bit of a higher standard than just abuse of discretion. But if he gave so many reasons, and so if some of the reasons this court doesn't agree with, that doesn't give it the authority to say that this entire ruling was incorrect and an abuse of discretion.
Why not? I don't understand that. I mean, where he made, was it 12, 14 pages of findings if 4 of them are not supported by the record? How do we determine whether or not it was an abuse of discretion to grant the motion?
Well, if he has 12 pages and several reasons, and some of those you don't think are tenable, then you would have to subtract those and see whether the rest of it still, supports his ruling, and that there's substantial evidence. So the question is, substantial evidence can only be determined once you take away what you don't agree with and see if the rest of the evidence is substantial.
But how do we determine if he would have made the same determination? It's not our determination, it's his.
So in other words, if you had told him before he did his ruling that the 704B reference he made wasn't correct, as counsel was saying, then what would he have done? Is that the question?
Correct. How would we know that? How would we know that he would come to that same discretionary conclusion that Fisher talks about?
Well, I think you'll have to see. Well, for example, in that particular case, even if the idea that the expert testimony somehow, unrelentingly showed the jury because of the objections made, that really what they wanted to do was to say Hunter did, intend to do certain things to promote the gang. Well, there are other things in that same part of the opinion of the ruling that talks about why the experts didn't actually give an alternate explanation, and that it didn't really tell the jury anything about gangs. They talked about certain times that other gang members had threatened people, but that's not the same as what Hunter might have done at that time. So because there's no alternative explanations the experts gave, so it really didn't eliminate the jury's understanding of gang culture. So that part is correct. So even if the expert testimony wasn't flawed like Judge Hanna said it was, the other part is certainly true. So I think you can assume that even if, that might be that was a make-weight argument, but the main argument was that the state did not prove intent.
Well, I guess that comes back to my ultimate question is how do we know if it was a make-weight argument or one of the substantive keystone arguments that he was trying to put forward?
Because I guess when I give three causes for something, even if one cause is incorrect, the other two are definitely, not make weight. He's saying that there are three ways to prove intent, and the official's testimony didn't prove it, and the culture, the gang membership was old, and rap music should not be taken as evidence that somebody is an active gang member, and that the expert's testimony basically about the fact that the police would be deterred from going into that territory by verbal threats, it was not credible, and that the other expert, Strong, was more credible in that, if gang member tells me I'm going to be killed, I'll say, well, stand in line with the other people who want to kill me. And that's how he understands police culture, and that's why the trial judge is there, to use his influence or his experience to determine these matters.
Well, but why do we allow him to bring in factual information from his past experiences when the jurors certainly didn't hear those factual claims, nor did the state have an opportunity to rebut those factual claims that he is relying on?
Well, the witness credibility determination is made by the jury, but if the trial judge in Fisher could determine that, given his experience, that's what Fisher says. Trial court can use its experience to determine witness credibility. So I don't see how one would use experience to determine credibility of a witness without using that experience. So, and whether the jury knew about that experience isn't necessarily the linchpin. How would the trial judge's experience ever be reflected to the jury? Does that answer your question, or?
Well, I have many more questions on that, but I would like to get to what I believe is probably one of the biggest issues in this case, and that is what authority under Rule 24 did he have to direct a verdict on the greater charge and nonetheless sustain the lesser charge?
What he did was Fisher and all other cases governing motions for new trial say that one must respect the jury verdict as much as one can, and so he found that the threatening and intimidating part of the jury verdict was fine, and he didn't want to go against the jury's verdict. So but this part of the verdict he didn't like, and he didn't think that was supported by the weight of the evidence. So he had, either he could decide.
Right. Do you have a case or a statute or a rule that would support what he did under granting a partial new trial on the greater, but then preventing that new trial by affirming the lesser?
Well, actually, I don't have a case in Arizona or a statute, but in Rule 59, when it comes to the civil motions for new trial, there is something that says that you can give, partial, you can do a motion for new trial on one issue, like the issue of damages. So, if you're, and courts have, Arizona Supreme Court has held that both civil and criminal motions for new trial are governed similarly. So that's the only direct evidence or direct reference I have to being able to give a new trial on one issue but not on others. There has to be, there's been some confusion in the briefs about the intent. The intent is governed by 13105, and that the defendant's objective was to engage in that conduct defining the offense or cause the result. The jury was instructed, but somehow there's a reasonable person that has been introduced in the state's briefs, and that is actually only applicable to 13-1202A1, which is a misdemeanor and where you have to show that it was a true threat because there's no intent element in the statute. But this court held in Harm that intent, there is an intent requirement in 13-1202A3, and so the state has to show that he threatened with the intent to promote the interests of a street gang. There's no reasonable person standard here. I just wanted to clarify that because there appears to be some confusion there. The trial judge divided the testimony. He talked about the fact that Hunter made those remarks only when his car is being towed, but earlier when people were there, they were angry. He was just, giving slurs, but not actually talking about gang. And then he said, well, he was, he appeared in rap videos recently, and that's not enough to show that he is an actually active gang member. And that expert testimony did not describe alternate explanations for Hunter's behavior. So, and he found the defense expert more credible. And the idea is that he found that there was no evidence that Hunter thought he could keep police away by threatening them. So without that belief, the intent finding was against the weight of the evidence. So that is the crux of his ruling. And even if, the other verbiage is additional, this part of it cannot be faulted. Now, the idea that he could, that what did he actually do? He decided that the jury verdict was to be respected, threatening and intimidating. He's not going to give a new trial on those because that might give a windfall to the defendant because he could be acquitted next time. So, and then it's up to this court if, if this court agrees with that the motion for new trial was properly granted, then it can order whatever remedy it wants. But most defendants, of course, want an entirely new trial. And courts often deny their motions because when they find the jury verdict supports the conviction of a lesser included offense.
But the defendant in this case didn't object to that part of the order, did it? And you're saying the defendant wanted that verdict to remain, he did not want that verdict to remain, but there was no objection to the court's order, was there?
Well, I guess the defendant had, the ruling happened, the sentencing was going to take place, and on that day, the ruling came down, and that's where it was. So I guess if there was any objection, then that would have to be made on appeal because the judge had already decided, had already issued the ruling. But I'm saying that in general, courts, most defendants want an entirely new trial, and court often deny their motions when they find the jury verdict supports the conviction of a lesser included offense. And
isn't that part of the reason why Fisher was decided the way it was, is that we weren't allowing a judge to supplant completely what the jury did by coming to like a Rule 20 verdict where he's saying there wasn't sufficient evidence, we're done, as opposed to the more deference that Fisher now says we have to give an order for new trial because it's going to be sent back and the jury function will still be available to all of the parties, and that they're the ones who are going to make the decisions about whether substantial evidence has been presented to find him guilty again. Doesn't that take away something from everyone except your client?
Well, I guess what Judge Hanna did is that he found that the threatening or intimidating was established by that old jury verdict, by the first jury verdict. So there's no reason to have another jury decide that issue. That he didn't find that that part of it was against the weight of the evidence. Given even all the facts there, he thought threatening and intimidating had occurred. So why would there be a reason to have another jury decide the same issue when no fault can be found with the first jury's determination of that issue?
Well, because the state's not getting an opportunity to then have a new trial on the issue of whether it was with the intent to promote the gang, which is what his order was saying should happen. That's the rule that he made the finding under. It was a rule that allows the state to have a new trial.
Well, actually, he didn't say anything about whether there should be a new trial on the felony intent, the intent for the felony. He just said that there's a motion for new trial is granted with respect to that issue. But it was against the weight of the evidence that there was an intent to promote and further the gang interest.
Right, but he was setting sentencing, wasn't he? So that was going to be the end of the case in his mind.
Well, he had set sentencing before he actually ruled on the, on the motion for new trial. He set sentencing because there were verdicts, and then he decided that no, this is the way I want to give, I want to rule on the motion for new trial, and I'm going to find that that a new trial should be given, and then everything is stayed because the state appeals it.
Oh, hold on. I think, not to be disrespectful, but I think you're speaking out of both sides of your mouth here. He granted a new trial, which would envision a new trial. But now you're arguing that, oh, he didn't grant a new trial. He affirmed the verdict, which would prevent the new trial. Did I miss something on your argument?
I'm not sure what you are asking. All I'm saying
if
is,
he granted a new trial, why aren't we going to have a new trial, which we can only have if we have a trial on everything, not just we can't have a new trial if the original verdict on the lesser is affirmed.
If the original verdict for threatening and intimidating is affirmed, this court can still grant a new trial on the issue of intent to promote and tell the new jury, like we do in capital cases and penalty phases and so forth, is that guilt has been proved on threatening and intimidating. We just don't know what the intent was, as this jury has been impaneled to find the intent. This court is within its authority to do that.
Really? I'd like to know a case that says we can do that for an element of the offense versus a sentencing allegation.
If I
know of a case that says that?
No, I do not know a case, or I would have probably cited it in my brief. No, I don't know a case where it has actually happened that one, that's some elements. But if you think of the penalty phase in a capital trial and the guilt phase as one trial, there's some part of it that has been affirmed and some part of it that hasn't. So it is possible to draw a parallel to that and say one can tell a jury that the threatening has been established. You have to just find the intent with which the threats were made. I don't see anything legally objectionable in an appellate court going that route, if necessary. If this court has no other questions, I believe that I have said everything that I intended to say.
All right. Thank you, Ms. Roy.
Thank you.
Ms. Martin?
Yes, I wanted to make sure I turn my mic back on. Your Honor, we talked about how this long minute entry maybe is mostly right, and the fact is it isn't. You can basically take all the pieces of it and find errors, not just the phantom 704B violation, and not just the reasonable explanation that the defendant was upset about his car being towed away, but even where the judge is talking about saying that the state swayed the jury because of the ominous and scary terms like they say on TV about gang member, gang neighborhood, hostile environment. These were not ominous, and well, they were ominous and scary, but they weren't some kind of cultural stereotype. They were the facts of the case. And that is an abuse of discretion for the judge to make that up. And then the judge, again, makes this invented burden that the defendant has to subjectively actually believe that he can keep the police out of his neighborhood. And then the court adds the judge adds his superior knowledge of police culture and says that would never happen. It's not credible that the police would do anything different or stay out of the neighborhood, or or do something differently because of a threat. And the fact is that in this very case, like I said before, the police did do something different. So the judge makes an invented burden and then says, and I don't believe the police, we would never be able to ever prove any of these cases if the defendants had to subjectively believe that they would succeed. Sorry, my time is up.
Thank you. Judge Mc...
I can't hear anything.
We can't hear you, Judge McCurdy. You're muted.
Oh, look at me muting myself. So many litigants have attempted to do that over the years. I thank you, counsel, again for your briefing and your arguments here today. And we will deem the matter submitted and issue a decision in due course. Thank you.
Thank you, Your Honors.